A will is not enough when you become disabled or incapacitated. A will takes effect only when you die. Hi, I'm Varvara Gokea, the founder of The Inheritance Lawyer. We help families protect their children, their loved ones, their assets, and themselves before it's too late. Many people think that having a will they are protected, but having a will is never enough. In this video, I'm going to show you why you are not covered when you have just a will. So when does a will take effect? When you die. But what happens if you become disabled or incapacitated? Does the will cover you? Of course not. Clearly not. A will is not a plan for disability. It's a plan for death. So what do you think happens to all the people who become disabled every year and do not have a written plan? Well, the state of New York has a written plan for them. You might not have heard about it. It's called guardianship. When somebody cannot handle their affairs, a judge, the court, appoints a legal guardian to manage their legal affairs, pay the bills, make healthcare decisions, take care of the issues that the person cannot handle. Most of the time, the judges are reluctant to appoint the children of the disabled person as a legal guardian because if they spend the money on mom or dad, it comes out of their inheritance. So the judges want to appoint a social worker or a lawyer to take care of the disabled person, and they appoint these people as legal guardians. The legal guardians will spend everything until the last penny on the disabled person. The problem that I see with this issue is that the legal guardian has to spend all the money on the person they protect. Therefore, in many cases, there is no money left for their children to inherit. This is why a will does not protect you. A will is not planning for disability. Misconception number 2. I drafted a will and my loved ones know exactly how to divide my assets when I die. Well, this is not true. Because when you have a will, your loved ones have to go to court, file a petition, and allow the court to probe the validity of the will. It could take months. In order to avoid probate and going to court, sending your dearest and nearest down to the courthouse to allow them to inherit from you, it's much better to create a trust, and you don't have to go to court and you don't send your loved ones down to the courthouse. A trust is a replacement of the will, which doesn't have to be probated and doesn't have to go through the court process. There are conditions set in every trust that can be followed by the trustee, and your loved ones and yourself are protected. A will is less expensive to draft than a trust. But if you have just a will, you guarantee your loved ones will go to court, and going to court is expensive. It could be 3 times more expensive than administering the trust you create with the same conditions and no need for a will. As a matter of fact, Kiplinger Report a few years ago did a research, and they discovered that the average case, probate case in New York State takes about 2 years. And now imagine your loved ones have to pay maintenance, mortgage, gas, water, all the expenses of your home without having access to your money. The most important thing for me is that trusts keep my clients out of court, which leads us to the third reason. A will, to be probated, it's time consuming. And when you have to spend time paying all the bills, your loved ones will not have access to your money. So how are they going to pay your bills? Unfortunately, most of the time they pay the bills out of their own pocket. The fourth reason a will is not good enough is that a will is public. Think about it. The executor has to file the original will with the court. So anybody can go down to the courthouse and see what you left behind, what your loved ones inherited, and all the details of your will. Then, when your loved ones inherit, predators and creditors in cases could go after your loved ones. On the other hand, a trust is totally private, as opposed to the will that is public. So it gives a different level of protection to your loved ones. So having a will does not protect you in case of disability, doesn't protect your loved ones from probate, and exposes your loved ones to creditors, predators, and the public, because a will is public. This is why we advise clients to create trusts, to create comprehensive estate plans that include a will, a trust, power of attorneys, healthcare proxies, all the ancillary documents, so themselves and their loved ones and their assets are protected. If you want to explore your particular situation, I created the Inheritance Audit Meeting. This is a 15 to 30 minutes meeting with one of our legal assistants, and you get a checklist. You find out if you have all the documents in place. If you do have them, wonderful. If you don't, we can assist you in creating the additional documents. During the Inheritance Audit Meeting, we'll spend 15 to 30 minutes. You will receive some questions, a checklist, and we'll discover how protected or not protected you are. This is a free of charge meeting. Go ahead and schedule your Inheritance Audit Meeting now.